Okay, today we will have 4 presenters, and we are very fortunate. We have some very experienced experts in the field. They will be sharing some tax strategies, sharing information about wills and trusts and estate planning essentials, as well as charitable giving options and how to leave a legacy. Our presenters today include Laura Hansen with Breen in Person, Rene Millner with Breen in Person, both attorneys, as well as Paul Radeke with BerganKDV. He is a CFP and AIF, and Karl Samp, Executive Director of Brainerd Lakes Area Community Foundation. We hope that you find this information helpful, and if at any time you have questions, please feel free to write a question in the Q&A box, which can be found in the bottom of your screen. And at the end of the presentation, we will try and answer all of your questions. Please note that all of these professionals are available if you should have any questions or would like to contact them later. Today's session will also be recorded, so if you wish to review anything or share this information with friends or families or associates, that will be an option. So without further ado, please welcome Laura Hansen, Breen in Person.
Okay. Well, thank you for joining us today. This is my first webinar presentation, and although I'm looking at a computer, I'm still a little bit nervous, I have to admit. So I'll be presenting on the estate planning process. So what I'll be talking about is the process itself and the steps that we go through with our clients to complete an estate plan. We find that by completing all of these steps, that's the best way for us to help our clients develop a plan that best meets their needs and reaches their goals. So estate planning is more than a set of documents. It's planning that involves many areas of our lives and incorporates many different issues. And it also addresses things that can happen both during our lifetime as well as when we pass away. So the typical documents that make up an estate plan are a healthcare directive, a power of attorney document, a will, and sometimes a trust. My colleague Rene Millner, she's going to go into detail about each of these documents. She will explain their purpose and what they accomplish and what they can prevent. I think estate planning can feel a little bit overwhelming because it does involve so many aspects of our lives and so many different issues. We talk about probate and taxes, health and capacity issues, long-term care, of course, what we typically think about, which is who gets our assets when we pass away. There are also family dynamics involved, and we each have our own unique family dynamics. My son calls these internal affairs. So the goal of an estate plan is to address all of these issues as thoroughly as possible. And what I want to stress is that one of the greatest benefits of an estate plan is that it puts our family members or our loved ones in a position to help us if we need them to help us. And also in the best position to take care of things when we pass away. I truly feel that it's a gift to our family. So now let's get started, and we'll go through each step of the estate planning process. Step 1 is to meet with an estate planning attorney. And at my first meeting with clients, it typically takes about an hour to an hour and a half. And at the start of the meeting, I like to ask them about what their worries are, what their concerns are. I like to ask them what they're trying to accomplish in their estate plan. I often find that there's a particular issue or concern that has brought them to my office. And so I'd like to talk about that right away. I feel usually the tension and there's more relaxation when we talk about that. So often clients have had a bad experience when a parent or a family member has passed away. And they want to prevent that same bad experience from happening when they pass away. They want to avoid probate. They want to avoid conflict within the family and other complications. Some clients have had a very good experience when their parents have passed away. They're grateful that their parents did have an estate plan in place and had everything addressed and taken care of. And so they want to do the same for their own family. Some clients are concerned about their own physical or cognitive health. For example, I've had 50-year-olds who come in and want to complete a trust plan because they may have Alzheimer's or another cognitive disease within their family. And so they want to put things in place so that somebody they trust has the ability to step in and kind of take over if they need them to during their lifetime. Some clients have a special property like a family cabin or a family farm, and they want to lay the groundwork for the next generation of owners. My client's family situation is important too, of course. So we talk about whether they have kids together, they consider themselves a blended family, where their kids live, what is their relationship with their kids, if they don't have kids, who are other trusted loved ones and individuals. So in the documents that I mentioned, it's important to keep in mind that we name people to play roles. We name people to step in and do things for us. And so I like to talk about that right away and get the clients thinking about who they might name in each document to play that role. And Rene will talk about those roles more in depth in her presentation. So in my first meeting with clients, of course, we talk about how they want their assets distributed when they pass away. We talk about any special concerns they might have with a particular family member. They might have a child with special needs. They might have a child with other issues such as addiction, credit problems, or marital problems. We talk about special gifts to grandchildren or to churches, charities. Talk about an age of distribution. And I like to include sort of a final oh no distribution clause in case the individuals they name don't survive them. We cover a lot of ground in this first meeting. The other part of the first meeting, which is step 2, is that we start creating a list of the client's assets. And this list includes everything. So it's real estate, bank accounts, investment accounts, retirement accounts. We note whether they're qualified accounts or not, or non-qualified. Life insurance, long-term care insurance policies. I also need to know if they have any business interests, if they have outstanding personal loans, do they have a safety deposit box, and other personal property. Most of my clients have what I call the normal Northern Minnesota DMV type assortment of vehicles. So I get to hear about pontoon boats and four-wheelers and trucks and the like. So it's, I'm thorough. I tell my clients that right away. And it's because it's very, very important to complete a complete list of the assets. So it's an important step. I mentioned probate earlier, and most clients, of course, want to avoid probate. And even a well-drafted estate plan, a probate can be required because one asset was left out. So here are some examples. Real estate is a very common trigger for probate. If an individual dies owning real estate in their own name, and that real estate doesn't automatically transfer to another person when they pass away through a joint tenancy or a transfer on death deed, or if they haven't already conveyed that real estate interest in a trust, then a probate will be required. So even a 1/10 interest that someone owns as tenants in common with their siblings, that's going to require a probate in Minnesota without careful and thorough planning ahead of time. So real estate, I asked that question several times in my initial meeting, and I also ask it more than once. I ask about contracts for deed, private financing in the form of mortgages, any family properties where they may share ownership with other family members. We talk about potential inheritances. We talk about mineral rights, gas and oil rights, timeshares. You get the idea. It needs to be an exhaustive list, and I'm always a little surprised about what may crop up. Again, real estate is often a trigger of probate, so we want to make sure that we capture everything. Even a single bank account can trigger a probate. If an individual owns a bank account and not in joint tenancy or joint ownership with another person, and there's more than $75,000 in that bank account when they pass away, a probate is going to be required before anyone is allowed access to the funds or even information about that account. The bank is going to require a probate and personal representative to be appointed before anyone can access it. Another trigger of probate can be the failure to name a beneficiary on a life insurance account, an investment account, or other retirement account. So we want to avoid what I call stranding an asset. And that's why this complete list of assets is imperative in the estate planning process. As I explain later, we address each asset and it's how it's titled, whether it's to be retitled, whether it's to be titled in a trust, and if not, then what POD, TOD, or beneficiary designation is going to be added to that account. And those are all ways to make sure that title transfers automatically when somebody passes away. So step 3 is to choose the estate plan, draft documents, and then have a signing appointment. And there are a few basic types of estate plans that my clients put in place. And these include what I call a will plan with a TOD, or transfer on death deed. And I'll explain what that is in a little bit. A revocable trust plan, or something called an EB trust plan or a disclaimer trust plan. And the type of plan that my clients choose really depends on their mix of assets and also what their goals and needs are. A simple will plan with a transfer on death deed is a very good plan for someone who owns maybe a single parcel of real estate and who may only have 1 or 2 heirs or beneficiaries who they want to name. It's with that transfer on death deed, and it's often called a TOD, as I've mentioned, that we're able to avoid probate for someone who owns just a single parcel of real estate. And when someone records a TOD has to be recorded before death, but once that's recorded, it's actually a fairly simple process to address the title and change it from the person who died to the people who are named as beneficiaries on the transfer on death deed. Just 2 documents are required to be recorded at the recorder's office and filing fees paid, and that's much simpler than a probate. So a TOD sounds simple, but it can get complicated quickly when we have more than 1 person involved. With a transfer on death deed, but really all you can do is say, when I die, I want this real estate to go to these people. So if it's 1 or 2 people, that's okay. If we have 5 people and all of them are married, all 5 people are entitled and have an interest in the property. Their spouses have a marital interest in the property, and all of them would be required to sign a deed. If the property is sold, all of them will be required to sign other documents relating to the property. So they are simple. They're not always the best. They're not always the best option when we have a lot of people involved. And so I call them kind of I call a TOD a blunt instrument. A revocable trust plan and other trust plans really provide more flexibility. And they're also better when we're talking about several parcels of real estate and maybe several people involved. A trust plan is very effective for avoiding probate when someone owns property in more than 1 state. We can set up one trust in Minnesota, and we can title property in Minnesota and Wisconsin and Florida and other states in that single trust. And we are avoiding probates in more than one state. So it's very effective for that. A trust also gives us more options and more flexibility for saying what we want done with particular assets when we pass away. It allows us to sort of set out contingencies and succession, and it really has more flexibility than a simple will plan. A trust plan avoids probate because it carries on after we pass away, and assets are titled in the trust now when we put the trust plan in place. After death, when a trust plan is put in place, after death, the successor trustee then steps in, and it's the successor trustee who has authorities over the assets within the trust. They have the responsibility to manage them, but they do have the power and authority to sell the assets if that's what's appropriate. And then we have fewer people involved to sign documents and make decisions and the like. An AB trust plan involves using two trusts, and it's typically to avoid probate and also for estate tax purposes. And I'll talk a little bit about estate taxes later in my presentation. Otherwise, an AB trust plan and other two trust plans have a lot of the same features as a revocable trust plan. Okay, so step 4 is to address the title to each asset, retitle assets, and complete beneficiary designations. As I've said, titling is a very important step in the estate planning process. And unfortunately, it doesn't always get done. Once my clients have put their estate plan documents in place and they've come back for their signing meeting, then we return to that list of assets, that inventory of assets. By this time, I've created a spreadsheet of their assets, and on the spreadsheet, we list how each asset is owned currently, and whether there are any, and their values typically, because that gives us information for tax purposes. And then we note the current payable on deaths, which are called PODs, transfer on deaths, TODs, or other beneficiary designations. We also note whether a particular account is what's called a qualified account, which means it was qualified for tax deferment, or if it's a non-qualified account. Qualified accounts are typically IRAs, 401ks, and also similar retirement saving programs. So there are tax considerations when we're returning to this titling issue, and we have to keep those in mind when we're deciding whether something is retitled in the trust, or we name a person, an individual as a beneficiary, or if we name the trust as a beneficiary. I'm going to talk a little bit more about those tax issues, as I mentioned. And so as part of the estate planning process, some of the retitling we actually take care of for our clients on their behalf. Typically real estate, we will retitle in a trust, for example. We'll have them complete the TOD and take care of recording it. Anything real estate related, I tend to take care of for my clients. I have attorneys in Arizona and Florida who can prepare those out-of-state deeds if I need them to. And we have them ready here for the client to sign to take care of the retitling. And the rest of the titling work, though, needs to be completed by the client. So at the end of that signing a meeting, when we're going over the inventory of assets and we're talking about how each one of them is going to be treated, I kind of send with them with some to-dos and some homework because they need to complete those steps themselves. So they go back to their bank and maybe complete a payable on death designation, go to their financial advisor and do a transfer on death or another beneficiary designation. And I just help them as much as needed. Again, What we want to avoid is stranding an asset and not taking care of this titling step of the process, and causing the plan itself to unravel or become undermined by not getting this step done, or triggering a probate, like I mentioned before. So when my clients leave with their documents, I also give them a letter with instructions on completing these titling steps that they need to complete. And then I field lots of phone calls, and I'm happy to do that. I field phone calls so that as they interact with the institutions and they might need more documentation or they need to know how to fill out a form, we're here to help them with that. So at this point in my presentation, what I'd like to talk about are taxes. There are a number of taxes that come into play when we do estate planning, and these include estate taxes and gift taxes, capital gains taxes, and income taxes. Different assets have different tax treatments, and so it's important to discuss these issues with each client's assets in mind as we're going through the estate plan process. There are estate taxes both at the federal level and at the state level here in Minnesota. The estate tax exemptions, and the exemption means that if our overall estate falls under the exemption, then we're not subject to the tax. These exemptions have increased substantially over recent years. Estate taxes, sometimes called death taxes, they're not popular, and that's understandable. This is a changing landscape, however, and I want to tell you that Paul is going to talk about recent changes in these laws. He's going to talk about the Secure Act, and he's also going to talk about trends and predictions a little bit on the estate tax issue. So I look forward to that presentation. Currently, the federal estate tax exemption is $11.58 million for an individual. There's something called portability. And so married couples can double their exemption and shield up to $23 million currently from estate taxes. The federal estate tax rate is high, so it's at 40% for anything over the exemption. So it's definitely something we want to avoid. Lifetime gifts are applied to this exemption. Any gifts in excess of the annual exclusion, I think right now, which is $15,000 per individual. In Minnesota, the estate tax exemption is $3 million per individual. The rates are 13 to 16%, and there is no portability between spouses. So it's very important to keep the Minnesota state tax in mind when working with married couples. Most people I work with, frankly, fall under the federal exemption as it is right now. But the Minnesota state tax exemption at $3 million without portability means that it can capture and more people's estates can be subject to that tax without some careful planning. And this is why. Spouses typically have all their assets go to their spouse when they pass away. In law school, we used to call these sweetheart wills. So if I die, everything goes to my husband, but if my husband dies first, everything goes to me. This transfer between spouses is not a taxable event because of something called the unlimited marital deduction. In Minnesota, because there is no portability for an estate tax exemption, the result of this is that a married couple can miss out on using an estate tax exemption on the first death. So I call this use it or lose it on the first death. And so for a married couple who has maybe an estate of $4, $5, $6 million, we really need to consider a 2-trust plan in order to make use of this exemption on the first death. And that's something called like an AB trust plan or a 2-disclaimer trust plan that I mentioned earlier. Another tax that comes into play when it comes to estate planning are capital gains tax and something called the step up in basis. As we all know, capital gains have to be paid on when we realize a gain on investment properties, including real estate. There are capital gains at the state and federal level, and the applicable tax rates are progressive based on income. So simply stated, capital gains are measured by the cost basis, by the difference between the cost basis, which is typically what we pay for a property or an investment, and the sales price of an asset. So we're taxed on this difference if it's a positive number. There's something called the step up in basis, and this impacts the capital gains tax that's paid on appreciated property. And I often find that my clients aren't very familiar with this. And what the step up in basis is that when somebody passes away, the basis on their assets that are transferred at the time of their death steps up to the fair market value on the date of death. So for property that is appreciated in value, there's a benefit to holding off on transferring assets to family members until after death versus gifting them during our lifetime. Because in contrast, if we give an asset to a person while we're alive, the cost basis in that property remains the same. So in other words, the donee receives the gift at the donor's cost basis, and there is no step up. This may all sound complicated, and I encourage you to talk to your tax advisor about this issue. I'm speaking here in very, very high level general terms, and I'm just describing these issues to sort of illustrate how they affect our estate planning process. So in estate planning, often this comes up with the family cabin, especially up here in Lake Country. And it plays out just as I described. So if the family cabin is gifted to the next generation of owners during the lifetime, there is no step up in basis. And so that cost basis transfers to the new owners. In contrast, if the current owners wait to transfer ownership until after they pass away, there's a step up in basis. So you can imagine for the family cabin that was purchased in 1965, that has maybe a cost basis of about $10,000, there's a significant benefit to waiting and transferring ownership as part of an estate plan after death. Another tax issue comes up when we talk about investment accounts, retirement accounts, and what we call qualified accounts. Qualified accounts are accounts that were qualified for tax deferment. And that means that income tax has not been paid on those funds and will be paid when distributions are taken out. And these are typically IRAs or 401ks and the like. So for qualified accounts, there are opportunities to further delay paying income taxes when spouses and other individual beneficiaries are named as beneficiaries on those accounts. These are called, we often hear these as the stretch rules, or it's just called the stretch IRA. And I think Paul's going to talk a little bit more about these issues. Generally, a spouse who is named as a beneficiary can stretch payments or RMDs, required minimum distributions, over his or her own lifetime. And an individual beneficiary can stretch payments or defer payments for 10 years. So getting back to our estate planning process and the titling issue, when we're looking at naming beneficiaries, we want to think about this issue and whether we want to take advantage of further tax deferment and these stretch rules. Because in contrast, if a trust is named as a beneficiary and payments accumulate in the trust, they don't flow through the trust, then the trust pays the income tax at that time. Trusts after death become irrevocable. They become a taxable entity, and they have compressed tax brackets and reach the highest marginal tax rate fairly quickly. There are ways to protect that tax treatment with certain language within a trust and also certain actions at the time of death. So it's just an important issue to think about and to address when we're doing that titling part of the trust of the estate planning process. The recently enacted CARES Act related to the COVID-19 pandemic also has some provisions impacting estate planning and charitable giving. And again, Paul's going to present on those issues later. Okay, so step 5 is to communicate with relevant parties, your family members typically, that you have completed your estate plan. So I encourage my clients to talk to their family members, that they have completed their estate plan and where family members could find those documents if need be. I encourage them to store them in a safe place. I kind of say safe from flood and fire, but not locked up so tight that people can't access them. If clients are going to store their documents in a safety deposit box, we want to make sure that the people who are named in the documents, the people who need to play roles, who have responsibilities, they can get into that safety deposit box. So we talked about those issues. I tell my clients to share their healthcare directive with their healthcare providers. We send extra copies of the healthcare directive, and I also encourage them to provide a copy of the healthcare directive to the people who they appoint. In contrast with the power of attorney document, I warn them that it's a really powerful document and they can be abused from time to time. So we keep that one a little bit closer to the vest. And I don't necessarily tell them to distribute it until it's needed. So step 5 is about communicating with the people you've appointed, communicated with family members, telling them that you have your estate plan completed, and then also where to safeguard the documents. The clients leave my office with original documents. Okay, step 6 is and the final step, is to update your estate plan as needed. So as I wrap up the estate planning process with my clients, I remind them that the estate plan is not just a set of documents. The estate plan shouldn't sit on a shelf, collect dust, and be forgotten. It's something that needs to be updated, it needs to be kept in mind, and it needs to be maintained over time. And so there are things that happen in our lives, or changes in our circumstances. And once we complete an estate plan, it's really important to keep the estate plan in mind when these things happen. So some of these things are things that I described before, which is purchasing a property or selling a property. If there's a substantial change in investments or a financial plan, if there's a birth, divorce, marriage, adoption, death in the family, that's the time to think about the estate plan and whether any of those events have an impact on it. Moving to another state, buying a second home, receiving an inheritance or other significant financial gain, changes in the tax laws. Those are some things to pay attention to. And, you know, quite simply opening a bank account or anything that has a title to it. In each case, I encourage my clients to think about how that should be incorporated into their estate plan that we just completed. So, as I mentioned, titling needs to be maintained, and assets can be titled in a trust, for example, or taken out of the trust. The assets aren't locked up in the trust, and the trust accommodates changes in that mix of assets as time moves on. If somebody has titled their house in their trust, then they sell it as trustee of their trust. And in order to maintain titling, then the next replacement house that they purchase, they need to title as they would take title to it, take ownership in it as trustee of their trust. And so that maintains the benefits of the trust, the benefits that they've spelled out, and also avoids probate. A TOD only attaches to one parcel of real estate. So if somebody has done a simple will plan with a TOD and then they sell their house, the TOD, once the house is sold, the TOD just becomes irrelevant. And if they buy a replacement house, a new house, then they need to complete a new TOD in order to maintain the plan and also avoid probate for that parcel of real estate. Again, same issues with opening a new bank account, opening a new investment account. Beneficiary designations should be redone if somebody passes away or if there are other changes in the family. So bottom line, it's all got to work together in the end. And so maintaining the estate plan is very important. This completes my presentation on the estate planning process. As a reminder, a good estate planning attorney can be a resource for you as issues arise in your life. We can put that estate plan in place for you. We can also help with other issues such as medical assistance qualification, if you have family members with special needs, incapacity planning, trust and estate administration, and a probate if one does end up being needed. Thank you for listening. I hope that you found my presentation helpful. And our next presenter is my colleague, Rene Millner. Rene works out of our Cross Lake office, and her practice areas are estate planning, estate and trust administration, probate, business and corporate law, and she also does guardianships and conservatorships. So I will turn it over to Rene. Thank you.
Good afternoon and welcome. Thanks for joining us this afternoon, everyone. Laura, thank you for the great picture of that sort of overall estate planning process. Both Laura and I follow that process, and although it may seem like there's quite a few steps and it is very thorough, it actually works out to be a pretty simple and streamlined process. We've really broken it down into pieces that make it very manageable, and we can guide you through that really easily. So there really is not a one-size-fits-all type of estate plan, and I want to dig into a little bit more detail on some of the key documents that you should consider including in your estate planning toolbox. It is so important that you do sit down with an experienced advisor to understand the impact of those various documents, what the options are to carry out your wishes. You know, during that hour and a half meeting, We really try to flesh out those goals. If you have, what's your legacy, what you want that to look like. We can pull in other advisors. When you have charitable intents, we can link in organizations like the Brainerd Lakes Community Foundation and really make it a nice, thorough process that's going to meet all of your needs. And I always remind clients, all estates need some type of planning, regardless of size. And it's really important, like Laura mentioned, review, refresh. Don't just put those documents in the drawer and hope that they're going to work 10 years, 20 years down the line. So let's get started with our first tool in our estate planning toolbox, which is the healthcare directive. So the healthcare directive really is just a written document that gives you the ability to name a trusted individual to make healthcare decisions on your behalf when you're unable to. So by setting up that healthcare directive, you get to decide who you want to be in charge of making those healthcare decisions and how you want your healthcare wishes to be carried out. So you've probably heard a variety of terms that reference these types of documents, giving that authority to someone to make healthcare decisions for you. And sometimes that can be a little bit confusing. So you hear things like living will, healthcare declarations, durable power of attorney for healthcare, medical power of attorney, or other written advance directives. Well, in 1998, Minnesota law changed so that people could just use one document for all of their healthcare instructions, and that is the healthcare directive. Unfortunately, they streamlined it and made this one document, but they don't have just one standard form that is used by everyone. So the form you have at Breen in person might look a little bit different than a form that you might pick up at Essentia Health or another law firm. But the key is the required pieces are going to be in each of the documents. So they might look a little bit different. I always remind people that everyone should have a healthcare document. Even if you're married, you should still have a healthcare directive that names your spouse, if you want them to, act on your behalf if you're unable to make your own healthcare decisions. So just by way of example, and an example of what happens if you don't have that healthcare directive, a couple years ago, I had a married couple where the husband had some really severe and unexpected medical issues, and he was unable to communicate his own medical wishes. Well, the healthcare organization would not just take direction from his spouse. They said, does he have a healthcare directive that lists you as the party that has the authority to give direction to us? Unfortunately, she did not. They had not completed any simple estate planning. So we ended up having to go through an emergency guardianship process with the court and have the wife appointed then as the person who could give or communicate those healthcare instructions on behalf of her husband. So you can imagine it's already a stressful time. You're dealing with an ill spouse, and now we're layering in legal hoops that you're having to jump through, not to mention the additional cost. That probably added a couple $1,000s to the bill to go through that emergency guardianship process. And when you go through the court system like that, it triggers annual reporting requirements too. So again, adding in more layers that really could be avoided if we have that healthcare directive, that simple document in place. The other type of situation that I just want to highlight and make sure that people are aware of, unmarried couples can be very important for them too, to have that healthcare directive document so that other party can speak on their behalf. Every once in a while, the healthcare system will say, okay, we'll listen to the spouse. I don't want to rely on that, but it can happen. But for unmarried couples, that sort of thing, it's not going to happen. So we want to make sure that we have that simple document in place. So let's move on to our next tool here in our estate planning toolbox, and that is our power of attorney form. So another small but powerful tool in that estate planning toolbox. So that power of attorney form, again, is a written document that gives you the ability to name a trusted individual, to access your financial accounts, and step in your shoes to manage your assets when you're unable to or you're unavailable to. So just like healthcare directives, I always advise clients to have several people lined up to step in and help if needed. Unfortunately, I see a lot of power of attorneys come into my office that have been in the client's folder for years, and they've only named a spouse. Well, that can be really challenging if maybe you're in a car accident together and you need somebody to step in and help. Or maybe your spouse has passed away and now you need help and we don't have anybody identified on the document. So it is really critical for both the healthcare directive and that power of attorney form to make sure that you've got people listed to step in. If my spouse can't do it, my daughter's going to do it. If my daughter can't do it, then my son is going to do it. And keep one single document. It keeps things so much easier to manage and maintain. I just ran across a file. An attorney drafted 16, that's right, 16 individual power of attorney forms. They drafted 8 for the spouse or the husband and 8 for the wife, and different people were named on each one of those forms. Can you imagine the chaos, the confusion that you might have if child number 1 comes in and says, no, I have the power to do it. Well, wait a minute. No, I have the power to do it. And if they're not operating consistently, you could just have a real mess with something like that. That's why I like to keep them on one form. We've got people listed sequentially, and it just makes administration so much easier. I would say probably the most common situation, or the time that we see that power of attorney form used the most, is where someone is struggling with some capacity issues. Oftentimes it's dementia, and they're no longer able to take care of paying their own bills. So it really serves as that bill pay function. The agent we have listed on that form can step in, they take the form to the bank, they're able to access the account and continue to get those bills paid for. That's probably the most common situation that we're activating or turning on that power of attorney form. So I usually see two different types of power of attorneys, and the most common by far is the Minnesota statutory short form. I can probably count on one hand how many times, or two, how many times that we've seen or used that common law power of attorney form. So on that Minnesota statutory form, financial organizations are used to seeing the form. They're very comfortable with the form. The statute identifies a variety or a list of categories, all the different things that that form might be used for. It could be used for transferring real property. It could be used for dealing with insurance or bonds or banking. So there's a whole variety of different financial related transactions that it can be used for. And you can actually say, I only want it to be used for these transactions and not these. Although I will just tell you, 98% of the forms, we just say all of the above because we don't know what that form might need to be used for in the future. So we want to make sure that we have the ability to address all the needs that might come up. The other thing that's really nice about that Minnesota statutory form is that you can specify on there if you want a certain type of reporting or an accounting that whoever is acting on your behalf might use or provide to others. You yourself have the ability to ask anytime to say, hey, what are you spending my money on? But oftentimes when these forms are being used, you don't have as much capacity usually. So I like that, especially where we'd have family dynamics that can be really challenging, or we have blended families. It can create some really nice transparency, and we can see what the dollars are being spent on, and it can just help those relationships stay calm and keep things as simple as possible. The other type of power of attorney form that I mentioned is that common law power of attorney. Although, like I say, used less frequently, it still can be a really important tool where a client needs more flexibility in their estate plan. So that power of attorney form can grant greater ability to do gifting, which might be really important with some larger estates that are bumping up against that Minnesota estate tax exemption, and we want to try to do some gifting so they don't have an estate tax that they might be subject to. Those common law forms can also be used to give different powers to different people. They can say different reporting requirements apply to different people. And you could also use the form to allow someone to create a trust on your behalf. So they can be really helpful and create some other flexible things and tools for your estate. I do find though, when that common law power of attorney form is used, because it is not as common, a lot of organizations want to run it through their legal department before it is used, and sometimes that can take a little bit longer to get that form activated then. So just as a practical note, I usually remind clients they need to connect with their financial advisor, share that power of attorney form with that advisor, and make sure that there are no additional steps that they need to take care of in that financial advisor system. Some of the financial houses require other forms get signed or completed that kind of go along with that power of attorney form. So it's good to just connect the two up then. Everyone should still have a power of attorney form. Again, even between spouses. So as I mentioned with those healthcare directives, just because you're married, it doesn't automatically give you authority over the assets of your spouse. So I would say probably the most common situation where that power of attorney form gets used between spouses is a situation where you have your homestead, you and your spouse own the property together. Your husband has struggled with some health issues. He's gone into the nursing home, and at some point he is no longer able to sign documents. He doesn't have the capacity anymore. Spouse living at home says, I just can't maintain the property anymore. I want to either move to something simple. That spouse is going to need a power of attorney that says, I have the authority to sign on my husband's behalf. If they don't have that form, we would need to go through a court proceeding and establish a conservatorship to give that spouse the authority to sign on behalf of the spouse that's in the nursing home. And again, just like that healthcare directive situation, we're now adding in more time, more money. That court proceeding, again, costing a lot more than a couple $100 just to get a power of attorney form in place. The other thing to remember, that power of attorney form terminates at death. So both of the documents we've talked about so far in our toolbox end when you pass away. So we need to look to other documents or tools to address your estate after you've passed away. So wills and trusts are going to be our next couple of slides here. So in that estate planning toolbox, we work to identify whether that will-based plan like Laura described or a trust-based estate plan is going to fit best with what you need. And again, as you're working with your attorney, your financial advisor, your advisory team, we're identifying those assets, the value of your estate, what that overall plan for distribution looks like, who you want to be in charge of wrapping up your estate. All of these things are going to guide us to help us determine if a will or a trust is the best fit for you. So what is the will? It is a written document that's created to tell others how you want to dispose of your property. Who's going to be your executor, or sometimes you hear the term personal representative. If you have minor children, this is the place that we want to identify who would be guardians for your children if something happened to you and your spouse. So wills are enforced or activated by going through that court process called probate. In Minnesota, that probate process is fairly streamlined, and it oftentimes can be completed in a pretty reasonable time frame after death. And reasonable time frame in my mind could be 6 months. You know, oftentimes you're waiting for the real estate to sell. So that's kind of your main variable in there. But then there's often, you know, family, it takes a little bit maybe to go through personal property, gather all the assets and pay the bills. So assuming there's no objections by heirs, there's not a lot of fighting, most probates are handled by default, which just means that no one has to go to court. We submit the paperwork, the judge signs it, and now your executor is approved to begin acting, paying bills, paying final expenses, gathering those assets, and doing those final distributions. So fees for probates are often done on an hourly basis here in Minnesota. Now that's different than states like Iowa or California, where fees are based on a percentage of the assets or the overall estate size. You can imagine that tends to be a lot bigger bill than when we do it here on an hourly basis. So functionally, just real quick, what does that probate process look like? So after that death of that second spouse, usually the kids are coming into my office, we're filling out a petition for probate, filing that with the court, filing the will with the court, waiting for that hearing. And then once we have that, the kids are appointed, or whoever that point person is to be your executor. Once they do all those administrative pieces I talked about, gathering assets, paying bills, we're going to file an accounting with the court that shows how the assets were spent and how they were distributed. That's the part that can be a little bit unsettling for some people, because that is public in the sense that anyone could walk in and take a look at the court filing to see what your will said, how assets were divided, how much was there. So like Laura mentioned too during her presentation, was that we do oftentimes look to other tools to help avoid that probate process that we might layer in with a will-based plan. We're going to talk about trust more in a minute, but beneficiary designations can be a great tool. Whoever we name on that beneficiary designation, when you pass away, that asset flows directly to them. So it doesn't go through any kind of court process. The same thing with a transfer on death deed. That's really like a beneficiary for your real estate. So whoever we've named on that deed, if we pass away, the steps they go through, filing affidavit of identity and survivorship and showing that you've passed, is enough to transfer that property to them. So really understanding your wishes, your family dynamics, and what those assets are and how we want to transfer them is really going to help us figure out the best tools in our estate planning toolbox to use. So let's move on, and we'll talk about trusts and how they contrast with a will. And I think you've heard some of that already with Laura's presentation, but the trust itself, again, is a written document that essentially is a contract, that any assets that we put into that trust are going to be managed in a specified way. It's going to designate who's going to benefit from those assets. It really becomes your rule book on how you distribute your estate. And then who's going to handle that distribution and wrap up your estate. So it sounds like a lot like a will, right? Well, the trust's biggest difference there from a will is how they're enforced and how they function. So that trust, at least the type that we're really talking about today, most commonly are created or put into existence while you're living. So you hear the terms like revocable trust or living trust. You're transferring title of assets to the trust during lifetime, or during that step through your estate planning process on titling, we might name the trust as a beneficiary, or we might have you set up a trust account with your financial advisor or at the bank. So really it's during that stage of the planning process that we're kind of linking the assets to the trust. Upon your death, that successor trustee is able to step in immediately and begin to administer your assets and wrap up your estate. So we work with clients on what are the steps that you need to do to begin that process. And what's nice is, depending on the comfort level of that trustee, we can say, here's your next 10 steps. You do 5, I'll do 5, or maybe that trustee says, no, you know what, I'm going to need your help with more of these, and we can do that. So we can figure it out and we can tailor it to whatever the needs are for each file. But no court process is required to have that successor trustee step in. And then there's no reporting that has to get filed with the court. So both documents, the will and the trust, contain your rule book on how to distribute your estate. We're just taking different paths to get to that final settlement and distribution. I do sometimes remind my clients, you're either going to pay on the front end or you're going to pay on the back end. So wills tend to be less expensive to set up on the front end, but you might have the probate cost on the back end. Trusts are generally more expensive on the front, and then we don't usually have that probate process on the back end. And so really knowing that, I think, is helpful, and then clients can figure out what process maybe fits best with their family and what they want to have happen. So there's no right or wrong. So let's look at some of the other reasons that you may want to consider having a trust. It really is not just probate avoidance that guides us on the type of plan that we pick. I have a lot of families that say, I don't have a whole lot of money. I don't think a trust is something that I need. And maybe they don't. Maybe that doesn't fit best for them. But when we start to look at some of these other reasons to pick a trust, they go, oh, that makes sense. That fits better with what I want to accomplish. So the first one there, incapacity of settlor. So the settlor is really whoever sets up the trust, or sometimes you hear the term grantor, but who's ever setting up the trust. And I actually have quite a few clients that like the idea of a trust in anticipation or planning for a day where their capacity, where they might be losing some of that capacity. So it can be very streamlined to have that successor trustee step in and help manage your assets. Sometimes there can be a little less resistance to that successor trustee versus using a power of attorney form. Again, both can function, but that's just been my experience on a couple of files. The second one there, incapacity of beneficiary. So that's situations like I have a minor child and in the eyes of the law, they don't have the capacity and they can't hold title to property. So you can set up a trust to manage the property on that minor's behalf. And you can, of course, designate the terms of what that distribution might look like. Another type of incapacity with respect to a beneficiary is things like mental or physical disabilities. So that might trigger us to create a specific type of trust for that beneficiary. So that might be a supplemental needs trust or a special needs trust. So people that have government benefits that they might be receiving connected to their disability, we want to make sure we don't jeopardize their benefits by receiving an inheritance from a grandparent or parent. So we really look at using different types of trusts in that situation. The third there, business succession planning. Laura and I have worked together on several files where we set up and use a trust to hold stock of a closely held family business. You can name an individual or a group of individuals as trustees of that property who have the ability to vote the stock. That way, if one of the members of the family passes or has incapacity issues, there's a means to continue that operation and control of that family business. The fourth, managing a particular asset, the family cabin. The lakes area here definitely has cornered the market there on that family cabin issue. Oftentimes we see those families that really struggle with how are we going to pass this asset on to the next generation? What should that look like? It's hard to just give it outright and say, all right, you guys figure it out, we're going to be gone. Well, there are some really nice tools, one being a family cabin trust that define how that property is going to be used, how the expenses will be shared, and what happens if somebody wants to get out. It can create a really nice rule book, again, so that it can minimize those conflicts and issues that might come up down the road. Real estate owned outside of Minnesota, just like Laura mentioned, up here, we've got a lot of families that maybe have a property in Florida or a property in Arizona or somewhere where it's a little bit warmer. And we worry about having that probate in multiple states. So when we hear that real estate owned outside of Minnesota, that's a flag for us to go, okay, this might be a good situation to consider setting up a trust so that we don't have probates in multiple states. Spendthrift children or children with drug and alcohol issues. If you have children that are poor money managers, trust can be a really nice tool to help manage that money on behalf of that child and really spell out how the terms of that payout should work and operate. And finally, tax planning. As we heard before, that Minnesota estate tax exemption is $3 million right now. And again, federal limit over $11 million per person. But that trust can be used as a tool to minimize some estate tax. So that's when we're looking at that A-B tax structure. And we want to make sure that both spouses can use that Minnesota exemption. So really that's it for me. I just wanted to say thank you for allowing me to share more detail about the estate planning toolbox and some of the documents that are in it. You can see why coordinating with your estate planning attorney and your advisory team is so important to ensure all the pieces fit together and we're operating in a streamlined and a tax efficient way. So I'll turn it over to Paul right now, Paul Radeke from BerganKDV, to give us that tax update.
Great, thank you. I will share my screen now. And great. All right, well, thank you, Rene. I'm Paul Radeke with BerganKDV. We're a CPA and business services firm located across the upper Midwest. And my particular office serves people and businesses between Twin Cities and Canada, basically. Today, I'm going to cover two acts that took effect this year, as well as the stated tax plans from the Republican and Democratic candidates and what effects those may have. So with that, first we will cover the CARES Act, the Coronavirus Aid, Relief, and Economic Securities Act. This was enacted by Congress in March this year, and it includes some really significant tax relief and charitable giving benefits. This act was really long overdue in stimulating philanthropy and could really make a significant impact to some cash-starved nonprofits right now. So one great effect is for individuals that don't itemize. The CARES Act actually makes a new charitable deduction available for individual taxpayers that it's called the universal deduction, and it allows for a charitable deduction of up to $300 per individual. And this is an above the line contribution that's deducted from the individual's income prior to the calculation of their adjusted gross income or their AGI. And the good part of this is that this will extend beyond the 2020 tax year. So that's a great one. Now for individuals that do itemize, one great thing that's happened is the adjusted gross income limit for cash contributions was increased. Cash contributions made in 2020, individuals can now elect to deduct up to 100% of their AGI. And that's up from 60%. Now, not everything is eligible for this. So for either individual or corporate donors to receive this benefit, they can only make qualified cash contributions to this public charity. The increased limits apply only to cash donations. So that means that other properties such as real assets, marketable securities, these wouldn't qualify for that. Now for the Secure Act. Now in most cases, historically, inherited IRA distributions have a 10-year distribution cap. The Secure Act eliminated the lifetime stretch provision from for non-spouse beneficiaries of an inherited IRA and other retirement accounts. There are exceptions though to this 10-year rule, and those are often for chronically ill heirs or disabled heirs. So if you're the beneficiary of an inherited IRA or 401k and the original owner has passed away prior to January 1st, 2020, no changes are needed. But if you have something, as Laura talked about earlier, something like a conduit trust or a see-through trust or a stretch trust, they all have some, they can be called different things, but essentially they're all talking about using that stretch. Really talk to your attorney to see if there's something that can be done to restructure what you're doing. Required minimum distributions for IRAs are required to start at age 72 now instead of at age 70 and a half. Now, this applies to individuals who turn 70 and a half in 2020 and beyond. This actually allows those who are working longer not to be required to withdraw their assets at 70 and a half. Now, interestingly, quite recently, there's a new bipartisan proposed act, not part of the Secure Act, and they're proposing to increase the RMD age to 75. So we'll see if that gains some traction. But so back to the Secure Act. One other great part of this is IRA contributions no longer have an age limit of 70 and a half. So you can continue to contribute to your traditional IRA past age 70 and a half as long as you're still working. So this brings traditional IRAs in closer alignment with Roth IRA and 401k plan rules. Now, this change doesn't apply to the 2019 tax year. It begins for the 2020 tax year, and you can make a contribution up to April 15th of 2021. The Secure Act did have some other provisions, including the ability to take tax-free distributions from a 529 plan. Those can be used to pay for eligible expenses related to beneficiaries' participation in registered apprenticeship programs, or excitingly, it can now be used to pay some student loans, not all, so check on that. Now on to the election. If you want to make your marketing and legal departments really nervous, tell them that you want to present on facts about an election. So as you'll see at the bottom of my slide, they inserted BerganKDV does not in any way endorse any presidential candidate or views. And they wanted me to read that out loud. So now that I've done that and taken care of the disclosure, what we do know is that changes are coming regardless of the outcome of the election. And what we do endorse is exactly what Laura and Rene said. Please reach out to your estate attorney to review your estate documents if you've got them already prepared. Keep those fresh and up to date, because there, as you heard, there are several rules that are going to expire in just a few short years or might be sooner. So now there are other topics. Of course, reach out to your CPA as well to review the tax strategy. Depending on the outcome of the election, there could be some choices you could make. We really wanted to focus today on the parts of the individual candidates' tax plans that would affect either you as individuals or your estate strategies. Of course, they were much broader, other corporate or business issues that they wanted to talk about. But so for that, we'll start with capital gains and dividends. Now, currently, the top tax rate for capital gains is 20% with an additional 3.8% net investment income tax. Biden's plan would actually eliminate the breaks for capital gains and dividends above 1 million, and those would be taxed at ordinary rates. Trump would reduce the capital gains rate to 15% from 20%, indexing for inflation. There was less detail that was really provided about a capital gains tax holiday, so we'll see if that if they would be elected, there would be more information about that. On estate taxes, the estate tax exemption for 2020 is $11,580,000. Now, the exemption is scheduled to revert to the pre-Tax Cut and Jobs Act levels after 2025. And currently, transfers of appreciated property at death get a step up in basis, as Rene and Laura talked about. Now, Biden would maintain the 2025 reversion and eliminate the current step up in basis on inherited assets. Trump would extend the exemption and would not change the transfer of appreciated property step up in basis. As Laura talked about in that step up in basis, that's in a lot of estate plans and what that might get used for. So this could actually possibly be a reason to accelerate some gifting if that would be the case. So it's, again, depending on which way we go, there's still something that you probably are going to want to do with your documents. Individual tax rates. Now, currently, the top marginal tax rate is 37%. This was lowered by the TCJA from 39.6. Biden said he would restore that 39.6 rate for taxable income above 400,000. Trump states that he would keep the 37%, and would enact a 10% rate cut, which would lower the 22% rate to 15%. The itemized deductions. So as you see, in 2020, the standard deduction is $12,400 for a single or married filing separate person, and $24,800 for married filing joint. Now, after 2025, the standard deduction is scheduled to revert to $6,350 and $12,700 respectively. The Tax Cut and Jobs Act also suspended the personal exemption for most individuals through 2025. And it also capped the state and local tax deduction at $10,000, and that'll remain in place until 2025, unless that's repealed. Now, Biden would enact a provision that would cap the tax benefits of itemized deductions at 28%. And for the SALT cap, Senate Minority Leader Charles Schumer has pledged to repeal the cap should Biden win in November. Trump said he would make the standard deductions permanent and he hasn't addressed the salt cap since last year. So that one we don't know more about. So thank you very much for listening today. And now we'll move on to Karl Samp, the Executive Director of the Brainerd Lakes Area Community Foundation.
Thank you very much, Paul, and appreciate your sharing that information. And also thank you to Rene and Laura for their expertise. So I'm going to talk a little bit about charitable giving, and there was a question in the question and answer about if professionals talk to their clients about that. So when we get to the Q&A part right after I'm done, we'll talk a little more about that. We appreciate you all attending today. I think one of the things that we all hope for is that you're also in your estate planning, you're also considering what legacy do you want to leave behind after we pass. And, you know, in my case, you know, part of my legacy and my wife's is the children that we've left behind and the impact that they're going to make. And we think about the careers that we had and businesses we built and those different things. But there's also a legacy we can leave behind through our charity and our philanthropy. So I want to talk a little bit about that today. So Brainerd Lakes Area Community Foundation is part of a network of community foundations called CommunityGiving. And we have partners in Alexandria, Brainerd, the Central Minnesota Community Foundation in the St. Cloud area, Community Foundation of Carver County, and Willmar Area Community Foundation. And our mission statement across those is to engage people, connect resources, and build community. And the intent of community giving is to empower community foundations. So we're doing some work across the state and nationally as well. So whenever you hear me talk about BLACF, Brainerd Lakes Area Community Foundation, you can just plug in the names here on the different foundations. So Hollywood up in Alexandria and Carol Turno and the St. Cloud area, and Sarah Carlson working in the Willmar area. And my coworker, Terry, who you heard from earlier, is supporting Carver County right now. So you could talk to Terry if you want to do something in the Carver County area. So that's your contact. So this is just not for Brainerd folks. So there's some basic information about Brainerd. Brainerd and Willmar were both established April 30th, 1998, and joined in with Central Minnesota Community Foundation. I'm not going to go through the data, but I do want to say the last two bullets, we do help make philanthropy easy, and we help generous people change lives and communities through their philanthropy. So that's what we do. So we're just going to talk a little bit about why work with the Community Foundation, and in particular one of the Community Giving foundations. So we provide convenience for donors where they can do one gift and get one tax receipt and then make several grants across from that gift. We provide for personal and professional service, so split interest, gift expertise. We can do charitable remainder trust, gift annuities, charitable lead trust, life estates, etc. And we have software for gift calculations and illustrations. So I'm just going to go through a few scenarios here. So leaving your legacy. So you've heard today, maybe a person or a couple have no children, or the children do not need the entire estate, or part of the estate could be lost to estate taxes. So the couple or individual could create a legacy gift or a bequest that will make an impact into perpetuity with a named fund, or a gift to one of the community foundations, Community Impact Fund, for local grant making for identified community needs now and into the future. So you can reduce that estate tax and leave your legacy. The IRA charitable rollover. So individuals or couple have one or two IRAs in their estate, which will be taxed as income upon distribution upon their passing. So they can designate a charity or a fund at one of the community foundations as the beneficiary, thus avoiding income taxes being taken out of that qualified distribution. So that's one we always encourage through your estate, and to make these qualified funds maybe your first source of charitable giving from your estate. Another situation where the client's heirs to inherit a substantial qualified funds and income only can be spread out over 10 years with the new tax law. You heard about that earlier from our folks, causing a tax impact on those heirs. So an alternative to what was formerly the stretch IRA is a testamentary charitable gift annuity. So that charitable gift annuity can be set up where the heirs begin to receive an annual income starting at age 55, and that can be spread out then over their entire lifetime. So that's a way to get back that stretching that those payments out and not having the tax impact on the heirs as much. So, and then after their passing, the remainder goes to the charity of the donor's choice. Also just standard charitable gift annuities. So let's say there's a client who has fixed incomes for secure principal and regular earnings, but CD and bank rates are so low right now. So that person, if they have charitable intent could set up a charitable gift annuity or charitable remainder unit trust that can provide a much larger annual income and receive a tax benefit as well. And then once again, the remainder after their passing goes to their charities of choice or a charitable fund. We can assist with charitable gift annuities. If you're going to do a charitable remainder trust, then you're going to want to talk to an attorney and assistance on that. Okay, gift of appreciated assets. So it was talked about, capital gains being, Laura talked about capital gains taxes as being one of the considerations. So if the client has charitable intent and appreciated stock or real estate and wants to avoid capital gains being taken out upon that sale, they can donate that appreciated stock or real estate and receive the full value as a tax deduction and pay no tax on the capital gain then if it's donated. If they love that stock in their lifetime and want to donate it while they're living, they love that stock, they can buy the stock back at a higher cost basis then. And so the tax impact won't be as great when it's sold or gifted through their estate. So once again, if in an estate, they can gift that to avoid capital gains taxes. We talked about the IRAs. The client reaches 72 and must take an annual minimum distribution of their IRA and pay income tax on that. So once again, this should be one of your first sources of charitable giving, where you can donate your annual minimum distribution or required minimum distribution directly to a charity to avoid paying income taxes on that donated amount and save your cash for other uses then. You can also use your remaining IRA in a bequest to avoid taxation of that IRA, as we talked about earlier. You can gift your annual minimum distribution to, you could potentially purchase a life insurance policy to leave to a charitable fund or a charity. We've heard this a lot with the new tax laws of bunching your gifts. So with the new higher standard deduction, doesn't provide as many, you have to have much more in deductions to receive a benefit to itemize. So one thing folks are encouraged to do is bunch your charitable gifts into a single year, take the itemized deduction that year, and then gift it out. And you can do that through a donor advised fund, for all your charities. So you can make one large gift to a donor advised fund for an itemized deduction that year, and then you can gift off that fund for several years to come while taking the standard deduction in those future years, and then repeat as necessary. You can also appoint successor advisors to that fund, so your children could become successor advisors. So that's the information I wanted to share on charitable giving. So we hope you all consider that as well in your estate plans, and talk to your professional advisors about how you can work that in. So Terry's going to manage any questions and answers that we might have right now. And I got to stop my share, I guess.
Thank you very much, Karl, and all of our presenters today. You did a wonderful job. That was a lot of information. And hopefully all of our attendees found value in all of the information that was presented today. We do have one question, as Karl mentioned earlier. The first question is about professional advisors. It says, I am curious, when attorneys meet with clients about estate planning, how much time do you typically spend discussing their goals and what sort of legacy they want to leave? So I don't know.
I'll just 2 cents. I did see that and was hoping that kind of covered it a little bit. Was, that those goals are definitely something that's very important, and finding out what they want that legacy to look like as part of that initial estate planning process. So that's usually our time to identify where we maybe want to bring in some additional advisors to help meet those needs and figure out where that best fit is. So it really is something that should be on the list of topics that we cover with that estate planning process.
Yeah, and I would probably add to that, you know, like Rene and Laura would have a kind of a prescribed list of questions or questionnaire that can help prompt some of the things that people are going to want to ask about and talk about, because you know, there's really no great training for individuals on this, right? They come in not knowing what they don't know and just want help. So guiding some of that conversation. So there really probably isn't, I wouldn't say a time limit that we have, Rene, you know, from a professional advisor standpoint, but it's oftentimes it's just really helpful to help guide through there and try to just prompt those questions too about other things that they would want to be asking, but just don't think of when they're here.
Laura,
Thank
anything
you
you
for
want?
your responses on that. Oh, Karl, did someone else have something?
I was just going to see if Laura wanted to add anything to that.
I'm not sure. Oh, Laura.
You're muted, Laura. Laura, you're on mute. There you go.
There you go.
So I think that people typically come in and plan to leave their assets to their kids. You know, that's what they have in mind. And so it's our job to maybe expand that thought. And I'm learning more and more about charitable giving as we put on these workshops. And one of the best statements, Karl, this came from you, and it really made an impact on me and my husband, but it's not so much what you give, what benefit you give for giving, it's more what good do you want to do? So I think that's a great way to think more about the impact of your estate plan versus just the dollars. So it's our job as estate planning attorneys to kind of bring that to clients. And I've used that phrase from time to time. So
Good to hear. Yeah, I mean, we all want our wealth to do good, whether it's to enhance our retirement or make our children's lives better. You know, but there's other ways that we can also really do good with that wealth, and making, you know, changing lives in your community through a gift is also a great way to do that.
Okay, thank you again. We do have another question that came in, and it's about naming a charity. So do you have a suggestion on how to encourage clients who name a specific charity in their estate plan to inform that charity? Should they do that during their lifetime, especially if a fund or a special provision needs attention by this charity? Would anyone like to take that one?
Well, I would certainly recommend that person ask their professional advisors, or the professional advisor should ask the people, do you want the charity to know about this gift during your lifetime still, or not? Do you want it to be a pleasant surprise to them down the road? But I would think that would be up to the client, but I'll let my peers here answer too.
I would agree with that. And I would also say sometimes there are specific ways that the charity should be identified, whether it's on the beneficiary designation or in their estate planning documents. So that can be helpful if we can connect it up with that organization and make sure that we're identifying it appropriately.
And we see it done both ways. Sometimes I probably would advocate for telling the organization, just so that maybe there's something that they, you know, have that they could plan for, or that they want to be able to show you their gratitude and thanks. But oftentimes there are people that just want to do it anonymously as well. So they don't get informed of those. So we do see it for both ways, and it's just whatever's right for the donor.
Okay, I believe that is all the questions, right, Perry?
Correct.
Okay, so I want to once again thank Laura, Rene, and Paul and Terry for helping to organize this. So thank you all for attending. And if you have any questions, don't hesitate to contact us. As Terry said, this is going to be recorded, or it has been recorded. Will be available on our website. So if you want to refer anyone else to watch it, you can do that. You can get to any of us if you want to talk to Rene or Paul or Laura further. You know, let us know and we'll make the connection with them on that. So thank you again for your time, and we appreciate your interest in the subject, and thank you all for being here.